first of all, the rule of law has always been an important topic also for ED, and we've organized several events on this, and today we're very grateful to have two guests from Poland who've been right in the center of the crisis that we're witnessing, defending judges, defending attorneys across Poland. They're doing an incredible job winning awards, and they will today be able to tell us something about the situation on the ground, because it's often hard from abroad to really have to follow everything and understand what's actually going on. And final thing, this matter is not only for Poland, but for the whole system that we built up in the EU, the EU legal state, because if a Polish judge is no longer independent, this will affect the union as a whole. So the matter is crucial, and they will also tell us something about the last days, what happened, because we're in a decisive moment at this point. And on our second guest is also Gerald Knaus, who worked in the European Stability Initiative, writing many reports and trying to influence the debate with concrete proposals. So we have a more practical side, and I think I'll hand over to you now to give us, the audience, maybe an overview of what has been happening in the last few years.
Thanks a lot. Good morning to everyone. Let me first thank Eddie and Zoe and Francesca for this opportunity, and for you for coming. I'm here with a colleague, John Dalhuisen, who's been working on this topic together with other colleagues in ESI. Now for the last few years, we've been trying to alert Europeans, and what I would like to do is just give you a general background, because for the details, what's happening now, the judgments, the assessment of the situation in Poland, there couldn't be anybody better than our guests from free courts. But let me look at this from not the Polish point of view, but the European point of view, very quickly. How can the EU be more strategic in protecting the rule of law, where Poland is a case study, but raises bigger questions? Now, strategy, if the EU needs a strategy to protect the rule of law, is seeing the woods rather than the trees, seeing the causes rather than the symptoms. And in this case, the cause of Poland's rule of law crisis can actually be very easily identified. It is a specific government which has been elected and put in power in November 2015 with a specific vision, and at the heart of his government, driving this is a specific minister. Of course, he needs his coalition partners, he has others who think like him in parliament, but he is the single biggest beneficiary. And though most Europeans don't know his name, it's important to understand that this accumulation of powers in the hands of this man, Jobro, Minister of Justice and head of the General Prosecution Services in Poland, he's central to that story. So the cause of this crisis is political. The cause of the EU difficulties is institutional, that the EU has limited instruments, and I'll say something about this. And the big here are the four quivers, I'll go into them, the four possible tools, instruments the EU has. And the big question is, for this debate, can a government that is determined to undermine the rule of law be stopped with existing instruments? Does the EU have the instruments to stop a government that doesn't accidentally violate the rule of law, but intentionally, strategically, systematically? And if it could be stopped, how? So the causes of the crisis I will not recite, except in the very most general terms. There's been a collapse, this has been our first report on this in 2018, a collapse of the rule of law in a very short period of time, between late 2015, by the time we published this in 2018. The Venice Commission of the Council of Europe already said that Poland had acquired features of a Soviet justice system. And the shock was that what is this? The control of courts and judges and everybody in the courtroom, and the ability to punish those in the courtroom who don't act like the state wants them to act, that this could happen in Europe. We're used to this from other parts of the world, like Venezuela. The key actors were a coalition, of course, two parties especially, the Law and Justice Party, led by Kaczynski, and the other smaller coalition partner led by Jobro, the Minister of Justice. And then there were others in parliament. Again, I don't go into the details, but the key actor in the end, and he's become ever more powerful, has been Minister of Justice Jobro. We described him years ago as the most dangerous minister in Europe. because he is directly accumulating many of these powers. And as long as he is the Minister of Justice, this crisis will not be over. From the start, the European Commission has seen the dangers. Already in January 2016, it started the rule of law dialogue, the very first instrument. It gave recommendations. It started an infringement procedure going to the European Court of Justice. It even launched Article 7, which is a tool in the treaty, for the first time in its history, in December 2017. Since then, years have passed. Last summer, the European Court of Justice issued an order to suspend the activities of a chamber of Poland Supreme Court, a disciplinary chamber, which it found to be in violation of the EU treaty, because it could be used to intimidate judges. In response to this, the captured Constitutional Tribunal, which does essentially what the government wants and has been found to be deeply problematic by different international courts, including the European Court of Human Rights, 5-member panel just said we reject the order from the court in Luxembourg because we just don't consider that the Luxembourg court is relevant on this. The next day, the European Court of Justice issued a final judgment. So there was an order and then there was a judgment, saying that Poland had violated Article 19 of the treaty, which guarantees effective legal protection. This was taken by the Grand Chamber of the court. It was a historic decision. Here you see the chief, the president of the European Court of Justice, Kuhn Lennertz. In response to this, the Minister of Justice in Poland said, we don't care. Yielding to the European Union, yielding to foreign pressure is a road to nowhere. I mean, this wasn't subtle, this was very clear. Instead, he proposed to accelerate the takeover of the judiciary, to carry out a comprehensive reform, to do other things, to get even more power for the government. And I'd be very interested to see how in other ways, from our friends in recent months, in fact, he has extended his power, including on the National Council of the Judiciary recently. He has also humiliated the EU. When the commissioner responsible, Didier Reynders in Belgium, came to Warsaw, the Minister of Justice issued this tweet where he said, where he handed over pictures of destroyed Warsaw, which you probably know, 1944, the German army in the Second World War destroyed every building in Warsaw as punishment. There was nothing to be left. He gave these pictures of the National Socialist destruction and said to the commissioner from Belgium, these pictures show that Poles will be sensitive to the principle of equal treatment, sort of equalizing the Nazi aggression with the attempts by the Commission to protect the rule of law. Of course, Belgium was also occupied by Germany. The difficulties for the EU, however, are very obvious. I mean, it's not only that the EU is not an empire, here the Burmese police of the British Empire, here George Orwell. There's nothing like this, despite the propaganda of the far right. And this is a good thing. You know, the EU can't do what the UK did in Cyprus in 1957, you know, just rounding up people, arresting people, imposing its will in the member states. It doesn't have a single executive agency that can do that. It is also no federal state. There is no EU National Guard that in the US can preserve public safety order in times of emergency that you can send to a state in the south to impose judgments by the US Supreme Court. Such a thing doesn't exist. The EU is based on sovereign states coming together in the European Council, where the logic is, do des, I give to get, you have constant negotiations and bargaining. That's what keeps it together. That's how it works. Because in the end, everybody can get up and leave, as the Brits have shown. And this explains why the procedures to enforce things are so weak. So in the treaty you have an Article 7 procedure, which was, as I said, launched by the Commission against Poland to protect fundamental values, but it had no success, and here is why. 6 member states are enough to bring the procedure to a halt. If 6 member states say we don't want this to go on, it won't go on. The Commission knows there are more than 6, so it doesn't even try. Well, sorry, not the Commission, the Council Presidents. And this is why it doesn't work. There are 3 hurdles for Article 7. First, one needs to establish in the Council the risk of a breach of fundamental values. Then you need to establish that there is a breach, not just the risk. Then you need to agree on a sanction. To block establishing that there is a risk, 6 member states can block it. To say that it is actually a danger, 1 member state is enough to block it. And of course there will always be 1. Which means this tool is useless. It can't proceed, it can't work. In fact, the risk is if you put it to vote, it will be a defeat. And then the government will say, brilliant, see, we don't have a problem. Even if only a few will vote for that government. There is this new conditionality regulation, or rule of law regulation, from late 2020. This is in some ways even worse. 4 member states are enough to stop any sanctions, as long as 2 of them are big. That means concretely, because you need a qualified majority, that if you have at least 4 members with more than 35% of the population, and an abstention, vote of abstention is a vote against, the mechanism fails. Qualified majority in the case of Poland means this. If Hungary and Poland vote together, they already have more than 10% of the population. If Germany and France join them, it's over. Now the French and the Germans politically have made very clear in recent months they would not go against Poland. If Germany and Italy would go together, it's also over. That's enough to block it. If Italy, Spain and the 3 Baltic states abstain, it's also over. So you see there is basically, and this is why the Commission, I think, has been so reluctant to use this mechanism. It's likely to be defeated. And if it uses it once and it's defeated, well then, what's the future of that mechanism? So it's trying to use it on Hungary, but the chance is bigger. It's not going to use it on Poland from everything I hear. That leaves the oldest instrument, the European Court of Justice and infringement. And so here I'm coming to the end to the question of the strategy. Ursula von der Leyen was clear. She said, what happens in Poland is a direct challenge to the unity of the European legal order. It's unique because it's a systemic breakdown of the rule of law, which in this form has never happened anywhere before. But of those 4 tools that the Commission has, Article 7 we've seen, it's not very useful. The conditionality regulation is almost certain to fail. That leaves 2, linking it to the recovery fund and linking it to Article 260, which is the court and infringement procedures. Let's just look at those 2 before we close. The recovery fund is a new instrument set up in 2020. It is financially extremely interesting, and here the Commission has been holding back money so far for Poland and Hungary. The heavy lifting behind pressure to implement ECJ judgments has been linked to the recovery funding. The trouble is, the good thing is, that the Commission decides alone. I mean, this is almost by accident. Nobody, no member state, no council needs to interfere. If the Commission says we don't release the money, that is fine. And von der Leyen said in October what the conditions were. If Poland wants to see any money, it must end or reform the disciplinary regime. That's where we get to the debate today. But it's also an accidental power. If there would not have been this recovery funding, if there would not have been Corona, the Commission would not have this power. Finally, can the European Court of Justice help? This is the traditional instrument. Its president, Kuhn Lennartz, has said the EU itself is at stake, and the court has been very strong every time it was asked in its judgments. And there is always the option of penalties. According to Article 260 of the Treaty on the Functioning of the EU, the Commission can propose, if a member state doesn't implement the judgment, it can propose to go back to the court and ask for a fine. And this fine can be as big as the court wants it to be. There's nothing in the treaties that limits the court. So we've been proposing already 2 years ago, or last year, that in cases where the court finds that the rule of law is systematically violated, that Article 19, access effective protection of justice, is not there, the fine should be at least as high as in competition cases against companies, 1% of GDP. In the case of Poland, that would be 5 billion. And you can offset this against EU funding. But it could also be used against states that don't get EU funding or don't get more. This would dramatically strengthen the power of the court. Now, the Commission hasn't gone back to the court yet. That's part of the problem. The advantage of this instrument is that it can be supported by the European Parliament politically. It's launched by the Commission and it relies on the court. It does not rely on the Council. That is why I think it's the only instrument that really has a chance of being effective, if it would be used. The drawbacks are that the Commission has been very reluctant to impose high penalties. The good thing is that it doesn't actually matter. It has its own guidelines how high the penalty should be, but the court can ignore them if it wants to, if it considers it serious enough. The second drawback is it takes years. I mean, it takes a long time. That is probably the biggest problem. So why Poland matters should be clear. There is a massive threat to the basis of democracy and the rule of law, the independence of courts in a member state. And the man behind it, and the coalition behind it, is determined to go on. They've said it openly. There is a real risk that the European Court of Justice will be humiliated. It speaks out strongly, it is clear about the danger, it will fail to prevail. That is a real risk. And there is a real risk that EU institutions are not strategic and fast enough. On this, the jury is out. And there is a real risk that in the end, this man will prevail, and that his vision of the relationship between state and courts will be what guides Poland in the future. Now let's hear from our Polish friends. What's the battle at this moment?
Is it working? Yes. So thank you again for inviting us. That's actually our second time here in the Parliament, so it's very good to be back. I remember last time when I was sitting here, we were just after one of the trials in ECJ, and back then, that was almost 2 years ago, and back then we kind of thought that everything is possible, because of the ECJ acting and because of the judgments that should be implemented, and we kind of thought we can win this battle in the ECJ. And you will see that it's not that easy in the moment. Goran, of course, told the story, but current events in Poland shows that they don't have any will to either fulfill the judgments or to meet the milestones given by the European Commission to release the recovery fund. But just to be back about your main question, can the government be stopped, and about the mechanism that can be used, we do agree that only the penalties given by the ECJ or the recovery funds, blocking the recovery fund, is the mechanism that's actually effective or may be effective. All the other mechanisms are just in theory, and it's basically not working. And with the penalties, we are now having, as you probably know, €1 million penalty every day for not fulfilling the interim measure and judgments of the ECJ. So it gives us an amount over the €200 million last Sunday, and over a half of it was already deducted from the different sources that should be, of the funds that should be given to the Polish government. However, it didn't stop the government from not implementing. Again, the judgments were not meeting the requirements of the Commission. And yesterday, we at the Parliament, the same has passed a new law about how to fix actually the relation with the Commission and how to meet those milestones given by the Commission. And the milestones are basically, first one is to liquidate the disciplinary chamber. Second one is to change the disciplinary regime in a way that the judges will not be punished and having disciplinary proceedings because of the fact that they actually follow the EU judgment. Because just to remind you, you may probably know it already, a lot of Polish judges, they are having disciplinary proceedings because they follow either ECJ judgments or Strasbourg judgments. They are suspended because of that, mostly, and either by the President of the Court, Minister of Justice, or the disciplinary chamber itself. So whenever the judge in Poland says, I'm not going to sit with neo-judge is the person illegally appointed by the National Judicial Council, so the body that was already set by a lot of judgments, ECJ or Strasbourg. It was not illegally appointed. It was the ECJ, the National Judicial Council is the body in Poland that appoints the judges and promotes the judges, right? So if you want to appoint the judge or promote him, it has to go through this body. So they took over control of this body, of course, and even though we have at least several judgments saying this National Judicial Council was illegally appointed, this is the main sin of the system, it's pumping to the judiciary system the illegally appointed judges, it was not resolved. And the first, and it was, I would say, about the milestones. So the first milestone was to liquidate the disciplinary chamber. The second one was to stop the disciplinary regime in a way that the judges will not be punished for following the judgments. The third one was to restore the suspended judges, because we have a lot of judges suspended, not only because of following of the judgments, but because of their brave words or brave attitudes towards the government. And judges are having like over 300 disciplinary proceedings for sure pending against them. And the new law was implemented yesterday, and it is not even close to the requirements of the Commission that mentioned fulfilling the requirements of the judgment. So it is about liquidation of the disciplinary chamber, but in a way that those judges, the new judges being there, will not be removed, but they will be just put into the different chambers. So you see, you have like illegally appointed people in the Supreme Court, which was already told by both tribunals, Strasbourg and Luxembourg, but they will not remove them. They will just put them in the civil chamber, criminal chamber, labor chamber, and they will decide about the matters of the citizens still, right? And they will only change the name. That's going to be called differently. It's not going to be the disciplinary chamber, but the chamber of the something about the responsibility of the judges and advocates and so on. This is just a different name. But they will not touch the main. They did not touch the main issue, which is the National Judiciary Council itself. And it is not just also announced for the next 2 milestones. There is no explanation how, in what way they will restore the judges. They say, we will restore the judges, but it's not said. There's nothing about the time frame about it, and our interpretation of their actions is that they want to do it in a year or a year and a half, at least start the proceedings, and we will see what will happen. And also, they did not address the second milestone, which is the changing the disciplinary regime, because it's still in the martial law, and still the judge can be suspended for following the judgment. So we have now discussion. If you see our funds, you would see that we have like thousands of WhatsApp groups discussing with a lot of NGOs and even politicians. How can we actually explain that to the Commission that is so eager to close the deal and actually release the funds to the government, because we believe once the funds will be released upon those conditions, nothing can stop them. Nothing can stop Children, as they're all set to do even more damage to the judiciary system. And there's already a plan to that, because this is not the only so-called reforms he wants to implement. He wants to change the whole system as such, and he will do it once the funds will be released, I believe. And once they have money, they will not. They will take absolutely any action to do more harm to the citizens and to the judiciary system.
Well, after this very short but very concrete review by Gerald about what happened in Poland last 7 years, and having in mind our experiences on that battlefield, we can definitely say that the European Union do not have effective enough tools for the rule of law to prevail. Because what we are talking about right now is only the small part of problems that we have within the judiciary in Poland, because we didn't say, and those instruments described by Gerald do not touch actually the problem of constitutional court, do not touch the problem of prosecutor office, which is totally politicized in Poland, do not touch the problem of National Judiciary Council, actually, maybe part of this problem, but not in general, and other problems. So we can say, observing what is happening in our judiciary system, that it is totally violated, totally destroyed after these 7 years. And these these tools, these instruments that European Union has are not enough effective, definitely. The instrument which is a recovery fund, accidental weapon, like Gerard said, is the most effective because it's a huge money which our government wants very much, and they are, because of that recovery fund, they are negotiating with the European Commission. Without this recovery fund, I believe that there would be no negotiations with the Commission, because those penalties which are ruled by the European Court of Justice, like Sylvia said, it's over 200 billion euros for today, are not strong enough. It is a not strong enough instrument to force our government to do anything within this area of justice system. And looking in the future, we can say that European Union should think about other instruments that could systemically prevent those authoritarian and populistic movements like in Poland or Hungary. Because otherwise, I always say that we are in a critical moment of the European integration. The rule of law is a fundament, is an absolute pillar of the European Union. Without the rule of law, there is no European Union. So if the European Union will let Polish or Hungarian government to do whatever they want, to ignore rulings of the European Court of Justice, to ignore the rulings of the European Court of Human Rights, which are also very important in that system. If they let them to ignore those judgments, they let to ignore the whole legal system, European legal system. And that means that the integration of Europe will not prevail, will collapse. So this is not only our Polish or Hungarian problem, this is the problem of the whole integration of the whole European Union. And I believe that having it in mind these experiences of the last 7 years, the last 12 years in Hungary as well, European countries should think about more effective systems, should think about more effective tools, because those tools which were designed many years ago, or even this new tool which is a conditionality mechanism, is not from the political reasons, from legal reasons, it's not effective enough, as we can see. The question of majority, which can stop working of a conditionality mechanism and other circumstances that can stop working this mechanism as effective. So, looking at our Polish problem, we can say that without the cooperation of Polish society, without winning the election, without strong approach of Polish society, that battle cannot be won. And that battle cannot be won individually by the European Union. The European Union is not enough to win this battle for the rule of law in Poland, which is also a battle for the rule of law in Europe. Because, for example, our practices as lawyers, when we go to the courts, when we have everyday cases with the clients, we can see that this is the pan-European problem, because the judgments which are issued by Polish courts are also European judgments, because Polish judges are also European judges. So if the judgment in a family case, or a judgment in a commercial case, or in a criminal case is issued in Poland, it should be recognized in other countries of Europe, of European Union, automatically recognized. And if there is no trust for Polish system, which do not provide the guarantees of independent and impartial process and impartial trial, then those judgments which are issued by Polish judges, by Polish court, are not recognized in other countries as independent and impartial judgments. We have in practice these cases every day almost, because courts from all over Europe are coming to us and asking about expertise, if those judgments can be recognized, if anyone can be sent to Poland on the basis of European arrest warrant, and so on, so on. So this is a problem that touches all of us in Europe, and that's why I think that we should think about systemic solution for the problem. Thank you very much.
Yes, thanks a lot for your insights. I think we touched upon a lot of points now. What makes the situation in Poland unique is that it's the first time the European Court of Justice has said Article 19 to provide effective judicial protection is violated. That means for the first time in an EU country, a judge can fear consequences for the judgment he offers if it displeases the Minister of Justice, or as you said. So, I mean, this situation is unique, and as you said, because EU law is applied across the Union, it concerns us all, and the system itself is at stake. But you mentioned rightly the recovery fund as a powerful tool, and we are now at a critical moment because the Commission wants, of course, the implementation of the judgment, that the system changes, so that the disciplinary system that punishes judges, that this is abolished. So maybe I can go back to you. What is the situation moving forward now? So what can we do? We heard that yesterday the Polish Parliament announced that it will change the system. But as you said, is this actually no? It's cosmetic changes, so pretend so we get the money. So what is the way to move forward? Which tools do we have? Maybe you can say something.
I think it was just, wasn't that the guy?
I mean, it's to the panel.
Sure, yeah. I mean, what tools can we use as I mean, we should now work as hard as we can on the grounds of recovery funds, because it's happening now, right? So it is about to decide every moment now, and the negotiations are in a very advanced stage. So right now we should do everything that we can to actually explain to the Commission firstly that those changes are, as you said, cosmetic, and this is again available of the government only to get the money, and again explain to the Commission once you say yes to that, the whole system, not only in Poland but in Europe, will be destroyed forever, because as Michael said, it's already happening, and you maybe noticed that, for example, with the European arrest warrant mechanism, which was really effective, amazingly effective in the past. It was working like really automatically. Now it's not working that way. A lot of courts are now suspending this mechanism, suspended to send people to Poland because they are having doubts whether this person, once sent to Poland, will have the fair trial. And as Michael said, it may also cause influence the Hague Convention, the Hague Convention, so the relations between parents, having kids, foreigners from one country and another European country, so it can influence absolutely every area of our lives. So I think that right now we should just focus on that and press the Commission as much as we can that they should not close this deal with the conditions that are on the table. Once it is done, we are in huge trouble.
How it works with this process, because right now the Commission and the Polish government are closing the negotiations about the document of recovery and resilience plan, domestic plan. But this is only a document where our obligations, these 3 obligations which were demanded by the European Commission,
which were described by Ursula von der Leyen in October last year. This one condition is to liquidate the disciplinary chamber. Second is to reform the system of judicial disciplinary proceedings. And third point is to reinstate those judges who were illegally suspended by the disciplinary chamber. So none of these 3 points are fulfilled by the law, which was accepted yesterday by Polish government, by Polish parliament, because in the first point, like Sylvia described, the liquidation is not fake. We do not have real changes in the system of disciplinary proceedings, and we do not have effective reinstatement of judges. So we believe that even the Commission will sign, or the Polish government will sign this document, and the Commission will accept this document, which probably will happen this week, because Ursula von der Leyen planned her visit to Warsaw on 2nd of June, so next week. And it will happen probably. Then we'll have to, let's say, watch the Commission and press the Commission if those 3 milestones are to be fulfilled by Polish authorities. We can say that this law, which was passed by the Parliament, does not fulfill these 3 milestones, so the Commission should press the Polish government to do this, implement these 3 milestones and make it really effective. But also, we have these tools which were described today. So the second most effective tool, apart from recovery fund, is the infringement procedure. So the National Judiciary Council is the biggest problem in our judicial system. So the Commission, of course, is aware of that, because the judgments which were already issued by the European Court of Justice and by the European Court of Human Rights clearly said that this National Judiciary Council is not independent, should not appoint judges, and should be dismissed, and it should be replaced with a constitutionally appointed National Judiciary Council. So, of course, the European Commission has the right, has this tool, can start the infringement proceeding, can file a motion to the European Court of Justice for the interim measure to stop this pumping to the system new judges, invalidly appointed judges, because this is the problem. Because every day we have 10,000 judges, and 20% or even more than 20%, more than 2,000 judges are neo-judges. These judges were selected and appointed through this National Judiciary Council. So this is a real problem in everyday practice and in everyday working of the judicial system. So the National Judiciary Council, and as I said at the beginning, the Constitutional Court and the Prosecutor Office are 2 other issues that should be solved. The Prosecutor Office is the biggest problem from the point of view of EU law, because it is very hard to touch this problem from using these instruments that the European Union has. But the Constitutional Court is the issue that could be touched by the infringement procedure. And even the Parliament, in 2020, on the 17th of September, there was a resolution of the Parliament saying that the Commission should start 2 crucial infringement procedures. One regarding National Judicial Council, and second regarding the Constitutional Court. Now, having in mind that the Polish Constitutional Court was the first one in the history of the European Union that said that treaties violates the Polish Constitution. It never happened in the history of the European Union, which was indicated by Ursula von der Leyen in Strasbourg in October last year. She said it is the first time in the history of the European Union that the Constitutional Court of the member state said that European treaties do not follow Constitution.
new law that was adopted in the parliament yesterday, just before the visit of the commission, and that of course the government, the Polish government is under pressure because they have elections coming up, so they want to provide a success to their people, which would be the recovery fund. Who voted for this law yesterday? Which parties were involved, and what does this tell us about maybe the situation of the Justice Minister Jobro?
Mr. Jobro voted yes for this case. It was not easy though. There were a lot of negotiations between this party and Solidarna Polska, which is Mr. Jobro's party. They had an argument about the so-called test for the independent judge. So they decided to implement a mechanism in this new law to verify whether the judge sitting there is independent or not. But the trick is, it was not about the neo-judges, but about the judges as such. So the reason to implement this test was only to get rid of the problem with the neo-judge. So they didn't want to implement a solution that you can question the status of the judge only based of his legal procedure of being appointed as a judge. So now they've implemented this absurd test, which is really which is technically not even possible for the attorney like us to do it, because you have to prove because the fact that somebody was legally appointed is not enough to question the status of the judge. You have to have some other arguments. God knows who should it be. So in case of some of the judges very openly being against the independent judiciary, or other judges behaving terribly, you may have found in some of their quotes in media or whatever that you can use once having this judge that's not objective or not. But in regular cases, no way that attorney like us can even implement this test. And they were having argument around this, but finally they made a conclusion. So the answer to the question is all the right-wing parties, voted for this act, and all the opposition parties were against.
Yeah, there was a very slight majority of votes. It was 31 votes, and in our parliament has 460 members, so very slight.
And also, Michał said that it's very hard to explain to citizens the difference between signing the documents and releasing the funds. So we do know, as Ursula von der Leyen will come to Poland on 2nd of June, and that probably will happen, as you said, that they will sign papers. It doesn't mean, of course, that they will release the funds, but for the public, they will announce the huge victory. They will say, you see, we resolved this issue, sign the documents, the funds will be sent. And for us, it's going to be very hard to explain to the regular citizen that it's actually not the same, and this is a lot to be done. They will for sure picture this as a huge victory and huge compromise they have done in this area.
But answering your question, Francesca, about how they are going to announce it, of course they will announce it as a success for the public, but this is only one point. The second point, they are waiting for this money to win the election, because they need this money, not to spend them for purposes that they were designed by the European Union. They need this money for their political reasons to win the elections, and that's why they were planning the elections for this fall. If they get money early enough, but if they do not get this money early enough until fall, elections will be probably only in a constitutional term next year. But this is important for us. That's why we are fighting so much, and we are pressing so much the European Commission to watch if Polish government fulfills these 3 steps, these 3 milestones.
But really fulfills, because, for example, restoring the judges, Judge Paweł Judicial, he's one of the bravest judges, and he was suspended for over 2 years. And last week, my colleague was representing him, he was restored by the disciplinary chapter. Believe me, for us, it's extremely difficult to enter the building of the Supreme Court, which we always admire, and all the people there who were raised, in this, huge glory of the Supreme Court, and now you go there and you know that those people deciding, in your case, are not judges whatsoever, but you have to dress in your robe, go there and argue in front of them. It's terrible, terrible experience. But he was restored by the disciplinary chamber. I believe that it was only because to show the commission, okay, well, you see, you are doing something. But he was always a civil judge, very experienced one. So the president of the court took him back, but he moved him to the family department, which probably he has done family law during his course for the judge like 20 years ago, and he's of course very smart person, and he will manage. But you see, this is like the way they do it, right? They will restore him, but just push him to a different department, or to a different court, different district, whatever. And for openly they will say, "We did it." So I can give you 1,000 examples like that.
Yeah, maybe just to say we are actually, it's a bad and good news. The good news is that we are at the moment where the Commission has language. Like we are at the moment where the government is under pressure and they want a compromise desperately, which they hope to sell to the Commission as something that they want. The bad news is if the Commission accepts, what do we do next? So maybe turning back here, what do we do? How do we convince the Commission? How should we act?
Well, I would also have a question for you in terms of the last few months. We've had incredibly outspoken, I showed a few of the quotes, it wasn't just once, it was like for months and months, outspoken, the main representatives of the government, and above all, Minister of Justice, but he was not the only one, Kaczynski, Morawiecki, the Prime Minister, saying we don't accept the European Court of Justice. These judgments, we don't accept them. So now, actually, that would suggest from what's been happening, they basically say we only do this because of pressure from the Commission, because of the money. We don't accept the judgment, it's illegitimate, we will not accept other judgments. We question the whole legal order, we just do it for the money. Is this how they are basically explaining their U-turn? Because Jobbo said until recently, when this proposal was made by President Duda, that he will never vote for it. Now he votes for it. Is he basically saying, well, I vote for it because we get the money and then I will not change my intentions, I will not respect the court? And secondly, linked to this, do you fear, what we feared was that in the background, that there are plans then, once the money flows, to accelerate even more damaging changes, that there might be some deal between Jobbo and his small party, which is needed for the majority, and the rest, to then carry out some of these dangerous, the plans are basically to fire every judge in the country by abolishing all the court levels and reconstituting them. And then, now, there have been fights between the parties. Could there have been a compromise that basically Jobbo gets this to approve something, to get the money, and then we see even more destruction of the judiciary in the next few months? How likely is that?
Well, of course, we don't know what is the deal between them, but as far as we can observe what happened throughout the last couple of months and what Jobbo proposed, there is on the table a new draft legislation regarding the common courts system, and it changes the whole common court system. It redesigns the common court system, so actually all the common courts are liquidated and are replaced by a new system of common courts. And in that new system, first of all, there is a systemic acceptance of new judges, systemic acceptance of these appointments made by National Judicial Council. And second, there's enormous power of the Minister of Justice inside the common courts. He is entitled to show which judge will sit in which court. If it goes to the first instant court or the second instant court. Their idea, his idea, Jobbo's idea, is to pump the second instant court with his people. Because he has a control over the whole judgment. Even if the independent judge issues the judgment in the first instance, then he has a control in the second instance because their people are in the second instance as I said, enormous power. He has financial power in common courts. He has administrative power. He has a system of nominations, of delegations. It's unbelievable. So if this draft legislation would be passed through the parliament on the basis of deal that they arranged or signed between them, agreed between them, that would be the disaster. That would be such a huge violation of European law that never happened.
And also the reason to do that is to actually send all the judges to the new KRS. So now every judge has a sin on their shoulders, being appointed again because of the so-called reform, and just go through the process with the new KRS. And that would mean that those brave, amazing judges probably would say, no, we're not going to do it. We're going to go retired because we're not going to do it to the citizens. We're not going to go through this process because it's illegal, right? So then you don't have in the system those brave judges at all because they may probably say no to this new procedure, right? Not mention they will be sent to the different cities, of course, because he will say you will go there and you will go there, and based on this new act, you can also promote the judge if he likes. So for the good behavior, he can say, I'm going to promote you to the appeal court because I'm very happy with your actions. And he also, based on this act, he created so-called administrative supervision of his people in the ministry side that can actually interfere with absolutely every proceedings. Like now it is, of course, with the prosecutor office, they can interfere with every criminal proceedings. This is the way the prosecutor office works now in Poland. But then they want to copy that into the independent judiciary. So you have these supervisors of absolutely every proceeding, and we actually face that, because in our cases, even if it's like a civil case, but against, I don't know, one of those pictures showed the current judge of the Constitutional Tribunal, St. Petrovich. We filed a claim against him on behalf of the President of the Supreme Court. But to these proceedings, we had the National Prosecutor Office join the proceedings to supervise the proceedings. And believe me, with absolutely every of that cases, we have Prosecutor Office joining the proceedings. So I guess his idea is to have his own people with every proceeding supervising whenever he thinks it should be done, to just watch the judge and again, to increase the chilling effect, because once you have those supervisors, this is obvious that the judge sitting there feels the pressure as well, right?
Coming back to this political game that you asked about between law and justice and Jodro, I think that the reason why Jodro decided to vote for this act is that Law and Justice Kaczynski convinced him that this law doesn't change anything. And actually they will keep the power over the courts, they will keep the power over the disciplinary regime. They will never reinstate those judges who were suspended. So it looks like fulfilling the milestones of the European Commission, but in fact, it's keeping power and nothing changes. So maybe that's why they convinced him to vote, but on the other hand, they agreed that this law, which I described about common courts, will be preceded by the parliament. That is possible. And the other very important, or the most important issue is money from the recovery funds. They decided to vote together for this act, to present it to the European Commission as an implementation of three milestones, and they will ask for money. Those money are needed for the election, so that's why probably they agreed to stand together. Otherwise, Jodro would have to go out from the government and would never get back to power, because his party is too small. He has to play the game together with Law and Justice and together with Kaczynski.
Well, this shows us the fact that Jodro agreed to this deal, that it preserves his power, because otherwise, why would he agree to something where, so this in itself shows us the problematic aspect of the this whole cosmetic change, and as you described it very well, the system in itself is still there. So judges are still afraid, and I mean, Jacob's power to appoint different directors of president courts to launch proceedings remains. Maybe.
Just perhaps to sum this up for those who don't follow it so closely, because you've said it and we assume that everyone knows, but this Minister of Justice, who has control directly and indirectly over courts, is also the Prosecutor General. So in a courtroom, the people who stand in front of the court, the prosecutor is told, can be told in detail by the Minister of Justice what to do, how to proceed. There is direct control, and he has cleaned out the prosecution service in the first few years in office. He's replaced all the leading positions, so he controls directly, not indirectly, as we have in many systems, but directly each prosecutor. Then he can appoint the court presidents or dismiss court presidents. He's a member of the National Judicial Council, which has a president who is very close to him. And then, of course, as Prosecutor General, he can also launch criminal proceedings against judges if he doesn't like them. So he doesn't even need a disciplinary system alone. So and then on top of this, he wants to strengthen, as his proposal, his control over all the ordinary judges, first and second instance. So he has a plan. He's told everyone what the plan is. There's nothing secret. He said, and his deputies in the ministry have said in the past, we don't believe judges should ever judge against the state. I mean, that's his plan. There are quotes. That's how they behave. That's how they run campaigns. The trouble for the European Union is in this life, the European Union needs, the Commission and those who want to protect need to be strategic. And the only strategic player, I think so far, really strategic player, has been the European Court of Justice, which sees through this. Which is why the European Court of Justice has issued its judgment so strongly. It's done things it has never done before. Even those still modest fines, which are not like fines that you give in competition law, when you punish companies, fines are much bigger. Even those fines are much higher than anything in the past. So the signals from Luxembourg, from the court, is we take this very, very seriously, and this needs to be won. The question is if the rest of the other European institutions see that. And at the moment, that's the big risk.
Yeah, let's maybe open the floor. We have great guests also from the rule of law, so please feel free to address our panelists. And also if you have more concrete questions on what the situation is like in Poland, feel free. Yeah, Mine? Or...
Yes. Fairly simple question. If the Commission was to sign off on the recovery fund, on the argument that its three conditions were satisfied, does this obviously end the infringement proceedings relating to the disciplinary system? Is there any way they can sign off on the recovery fund, but still would just be too incoherent does it kill any prospect of 260 for the July 15 judgment and the Muslim resolution?
This is a very good question, but I am not sure if it's solved. But if the Commission accepts these steps taken by Polish authorities, and this law as a law which implements these three steps, it might result with
No, but don't you think that they told us during one of our meetings that this is still on the table, so they're not going to let that go until all the requirements of the judgments are fulfilled? So I don't think it will let that.
Yeah, but if they agree, if the Commission agree that, or if the Commission accepts this law as fully satisfied from the point of view of these three steps, it may happen that they will resign with the continuing of this infringement procedure. But let's get back to the Muslim law, because this
Perhaps explain what
on the 14th of February, on the Valentine's Day 2020, Polish authorities, the Polish Parliament passed a new law which says that the disciplinary court for the judge is when he questions the status of the neo-judge, which is appointed through this neo-national judicial council. When the judge says, no, the judgment which was issued by this neo-judge is improper, it's invalid, then it could be the disciplinary tort, and the disciplinary clerk can go to the disciplinary court and charge the judge for it. So this, the Mazel law, so-called Mazel law, was about this disciplinary tort. And this disciplinary tort is not liquidated by this do-double yesterday passed. So it stays, and this infringement procedure, where the interim measure was issued last year on the 14th of July, is about this Mazel law. So I believe that this procedure will be continued because of that.
I don't think that it will lead to the point that they will give up with the infringement proceedings. I think there's so many other things and those milestones they're working on. And I think that they probably said to us at some point, because we are not happy with those milestones, to be honest. We're not happy whatsoever, and they know it. So they told us so many times, like, we know you're not happy, this is something we have to work on and close deal, but all the other mechanisms are still on the table. We're not going to let that go. I don't think that, I will be very surprised if they do it.
But just to add to this then, but then if that would be the case, then the last half year has shown something that is very interesting. It has shown that the Commission has pressure, has a tool. If the amount of money is substantial enough, where even an ideologically very committed coalition feels that in terms of its political support, it needs to compromise. I mean, it can't just say we don't care, because Jean-Paul used to say, I don't care about the money. There was he even voted once against this recovery fund, knowing that others would vote for it. So this argument, we don't care what Brussels does, we don't need your money, we don't care what it... Suddenly it turns out this is just a bluff. That means that and going back to the architecture of European rule of law protection, if the European Commission would just obviously embrace and accept and apply the same logic to the rule of law that it applies to competition law, where it has fines that should deter further violations. That's the indication. You don't go to Google and say you pay a fine that is symbolic and then you can keep doing what you do, or to Microsoft or to VW. You go to these companies and have a fine that is supposed to deter them doing it again. So it has to be a substantial part of their turnover. If that logic, which we can use given the treaties and given the role of the European Court of Justice, it can do that. Now, if that logic would be embraced, if we recognize that in fact all these debates about new instruments in some ways have led us in the wrong direction, because every new instrument needs to be approved by unanimity, which we saw led to the conditionality mechanism being designed like it is. We have a tool, let's use it. It's a question of political will and strategy, and it could work, even in Poland, even against Rome. And that would then be a very encouraging message, because one would then feel that, in the end, of course, it's up to the Polish voters, who they vote, and Poland could always leave, like Britain. The EU will never send a policeman to enforce its laws in Poland, which is a good thing. But this could work. And that would be an encouraging message. And so in a sense, if the Commission would just be prepared to say, any time an Article 19 violation happens and is found by the ECJ, we will go for fines that are that big, and the court says we are prepared to do that, that in itself would be a massive deterrent already. And if it's applied once, a massive transformation of the whole rule of law protection in the EU.
Yes.
And how would we get to that point? Because you say that we need new instruments in the future, and obviously we do. But if Poland will have this money now, and if Hungary will have this money as well, because they could veto the EU ban on Russian oil, so it seemed to me like a point of no return. Then we will have no democracy, then we will have no rule of law in the European Union, and then it doesn't matter the new instruments in the future. unless we have a new EU without Poland and Hungary, and I don't want that. So we need. So it seems to me that we have until the 2nd of June. That's a very limited time, and that seems like a very good instrument. But how? You're working very hard. But what we do in Denmark is that should we try to influence the Danish commissioner, Margrethe Vestager, who has been very tough on European on this. So this is how.
Yeah.
So this is
we quoted the Danish commissioner in our report on this 1% principle. 1% of GDP as a fine in case you fundamentally violate the rule of law, which is the foundation of the whole EU. So we quoted her talking about competition law. And interestingly, in the guidelines the Commission has on Article 260, which is this asking for fines and infringement, it also says, the Commission, that this shouldn't be symbolic, that this should deter. I mean, the Commission itself says it. So if the philosophy of the Danish Commissioner becomes the philosophy of the Commission, moving from competition law, which is important for the single market, to the rule of law, which is even more important for the whole EU. If you move this philosophy, so in that respect, I think the countries and the commissioners from countries like Denmark, Sweden, the Netherlands, France, Germany, I think this could be a broader alliance, should just embrace this. And I fear a little bit the European Parliament has probably tactically made a mistake, spending too much time on the conditionality mechanism, fighting with the Commission, saying, you should use it, while not asking the obvious question, which, it's not that hard to ask the Commission, why aren't you using it? To which the Commission will say, because we would fail. Because we know from the Germans and French, we would fail. And using the mechanism against Poland, and then we fail, is worse than not using it. Because then, so I think if the debate just shifts to what can actually be done, and you're right on the timing, but here's the paradox. Vera Jourova and Didier Renders said last autumn that they would go to Article 260 and ask for a fine. They've said it publicly.
So from the Commission?
From the Commission, the commissioners, and they didn't do it yet. That I don't understand, because that would create a second Damocles sword hanging over the Polish government that could be used to ask for real changes. And if politically, I think, given everything that has been said, the Commission should ask from the Polish government now, beyond the 3 criteria, at least a 4th one, which is that they should admit that the judgment of the ECJ is legitimate. Force Jourova to state that this is actually a legitimate judgment. You can't have a Minister of Justice in a member state just throwing up. Of course, they are hiding behind the Constitutional Court, and then we get to the next problem. If you would have a stronger Council of Europe, those judgments on other parts of the Polish judiciary, and this is another thing we should aim for, that's separate. Countries like Denmark should really push the Council of Europe to be more effective in backing up judgments from the Strasbourg Court of Human Rights. This whole architecture, we've sort of created it for fair weather, assuming states just want to comply. And as we realized in Strasbourg, that's just not the case until Russia was kicked out. And there are others that don't comply. And as we realized in the EU, that's not the case. So we need to strengthen all these institutions, and I think the whole debate among the legal community, in the media, in national capitals, should be one of the strategically best tools to achieve that. And we have some, and we should focus more on them.
Do you agree?
Yes.
So Margrethe Vestager is
I think she can be a crucial member of the European Commission that can force, especially the President, Ursula von der Leyen, to keep that policy against the authoritarian governments in Poland and in Hungary. Because as I said at the beginning, otherwise we can collapse the whole European Union. And it is not an abstractive issue. I give you an example of a systemic problem in Poland. We have the case of Advanced Pharma and the judgment of Advanced Pharma, which was issued this year in February by European Court of Human Rights. Polish company had a case in Polish courts against the state. They just claimed the compensation from the Polish state. And they lost in the first instance, they lost in the second instance, and they went to the Supreme Court, to the civil chamber of the Supreme Court. And in the civil chamber of the Supreme Court, there's more than 50% of neo-judges. And the president of the Supreme Court civil chamber is also neo-judge. So they had a panel of 3 neo-judges. And these neo-judges issued the verdict saying that this complaint to the Supreme Court is rejected. So this company went to the European Court of Human Rights. And the European Court of Human Rights said that this is the violation of Article 6. So they didn't have the access to the independent and impartial court. And what this company can do right now? They went to us, this is our
But just to add to this, so that was a pharmaceutical company that actually had to withdraw from the market one of the medical supplements. And they went with that to the administrative court and they won. But they had to destroy it, so the damage to the company, like millions of zlotys, and then they went to the civil court, and they ended up in the Supreme Court, and they won 15,000 euros in Strasbourg, and we had millions of damage and 15,000 euros from the Strasbourg court, and the moral satisfaction. Yes, you won. You were not hurt by the real panel of judges.
But for the company, commercial company, it's not a satisfaction because they lost millions. And each company that will go to the court and will go to the Supreme Court and has a conflict with the state, and has a claim against the state, will lose because we have the Supreme Court pact of neo-judges. And what this company, this advanced pharma, can do right now, they can go again to the Supreme Court and say, look, we have a verdict of the European Court of Human Rights saying that this is a violation of the convention. And they will go back to the Supreme Court, and the Supreme Court will give them the same panel with the same neo-judges, and they will lose again.
Because the president of the civil chamber is a neo-judge.
Yeah, as well. So this is the example how the system is destroyed. And each investor, each company that will go to the court will lose. And it also applies to foreign investors. It also applies to Danish investors in property. This is how it works. That's why it's so important. And what I want to add that if anyone is interested, we prepared such a report which is called 2000 Days of Lawlessness.
Very depressing, right?
But it might be interesting as a record of violence in the rule of law area. We prepared it last year. It was 2000 days. Now it's almost 2000.
But it's updated on our.
But look,
we do it like every week on our website.
yes, it is on our website, but here you have on paper. It's a very detailed record of destruction of Polish system. So if you're really interested, we have it here.
And of course, the website on free courts is also, you can find the great the work they're doing. And the videos are only Polish, no?
Some of them are having the English subtitles
To inform what's
what is happening. So this is what we do. We inform the society when this is important, and for that we do all sorts of crazy things like creating movies with Judicial and others super famous directors just to convince people, hey, you should just notice this problem.
Yeah. Well, I think if you have any questions.
Well, there are so many things. So I exchanged my question for another one. Since we are in Denmark and since I am Norwegian, could you expand a little bit on how neighboring states like Norway or Denmark, Norway within the EEA, Denmark properly within the EU, how then politicians from our countries or other European countries have national interests at stake depending on how this plays out. say a little bit more. I think company law is potentially very significant, and family law, the arrest warrant to some extent, but almost, most fundamentally, what seems so insane, if I can allow myself to be rhetorical, is that you now have a constitutional tribunal which arbitrarily reinterprets treaties commitments relating Poland to other European countries, and that's an absolute scandal. I mean, that's destroying the very legal foundation for cooperation between states, and that has become a part of the battle over the disciplinary council, right? And it's a level which sort of annuls all the proceedings or all the commitments that Poland might make, right? They can annul them afterwards by instructing. So, well. Okay, maybe I try to answer my own question.
Yes, you
Can you do it better? Can you add, all this weight to it?
But is your question about what should be done by the Norwegian undermined politicians, and then
what should I say?
With that, or is it a question how should we talk to the Norwegian undermined politicians to tell them the story?
I guess I wanted to see how it is completely self-interested. How neighboring states like Denmark, Norway, Germany, whatever, should be really worried, considering their own interests.
I mean, I think the difficulty with politicians and the general public is that one has to try to, well, that's not a difficulty, that's a good challenge, frame these things in terms that are not too legal, not too complicated, not involving too many institutions. And I think the way one can do that is very simple. I mean, what we have here, the European Economic Community turning to the European Union, is this unique structure, which is sovereign states, with no central control, with no National Guard, with no FBI, with no national agency that enforces anything. Coming together and deciding we make law together. And then we apply it everywhere through national institutions. That is unique. We give up sovereignty, but in reality we retain control because it's national institutions. That only works if those national institutions are democratic and if the national courts in Poland are independent. Otherwise, whatever the Polish or Hungarian or in the future Italian, French, German government negotiates and agrees to, back home by telling its judges not to implement it, is meaningless. We can't integrate through law if we don't have independent courts in those member states. They can't make the wrong decision like courts always can. They can be corrupted like courts always can. This is all a problem. But if they are systematically under the control of the government of the day, then the order breaks down. And it's not I saying this. This is exactly the words from Kuhn Leonard, who speaks in very simple, easily understandable terms when he writes his essays, that the President of the European Court of Justice, where he says very, very simply, in a way that I think any politician that cares about the EU as this unique structure that has survived empires, it's still there after all these empires fell apart, Warsaw Pact fell apart, the Fourth Republic fell apart, we still have the structure created in 1957 developed. This is fragile, and that's what Kuhn Leonard says. And if we don't defend this, the independence of national courts from the control of national governments of the day, the whole thing, the principle behind it, risks collapsing. Now the paradox is that in Poland today, the majority of the population does not want this to collapse. The EU is popular. That is why the government, even this government, needs to pretend that it can have both things. It can do what it does to the courts, it can still be in the EU, it can still get the EU funding, it can still enjoy the benefits of the EU. And that creates an opening for smart politicians to just say, yes, this EU is popular, it's great, we want Poland to be a member, we want Hungary to be a member, forever, that's the goal. But you're destroying what makes it work. I think that's the non-legal, simple, what makes the EU unique and why this matters.
You want to add?
Yeah, exactly. I fully agree that convince politicians in member states that this is our common problem, that we should take care of it because otherwise we'll have a problem with the European Commission. And you know, especially after the war started in Ukraine, there is such a way of thinking that, okay, we can maybe forget for some time about the rule of law in Poland because they are on the border, they have the enemy at their gates, so they have other problems than the rule of law, so we can forget about the rule of law. On the opposite, we should press on that problem of the rule of law in Poland. Otherwise, the system will grow and we'll have really authoritarian regime in Poland, and it will be irreversible. It will be irreversible, and Poland won't stay in the European Union.
Yes, maybe we have a final question from, or is it resolved? No.
No, I'm just trying to get my head around this. When an EU member state is negotiating all these criteria before becoming a member, as far as I remember, when Erdogan tried to roll back some of the reforms he made when the EU was negotiating with Turkey, they suspended negotiations. And as far as I understand, we signed a treaty like when it took a lot of years to negotiate an exit package for Britain. So isn't it a breach of contract if a member state doesn't uphold all these criteria? And as far as I know, there's a pretty long list of legal criteria. So why can't they just suspend membership if a member state doesn't uphold these legal criteria? To me, it seems like a breach of contract. If we can hold, if you sign something, it's a contract or treaty. What's the legal rationale for that?
Well, that is true, but the difficulty is that there is a strategy behind it on the part of Poland and Hungary. They want a different EU. And they want an EU which holds together, where there are these transfers, which might, cooperate on certain issues, but not interfere at all, and that's what they say, in issues of fundamental rights and the rule of law. I mean, what Jorbo says is, and that's what the Constitutional Court in Poland has been captured by the government says, this is, on these issues we are totally southern. The risk is that if they get away with this, there will be a different EU. Like we have seen the emergence of a different Council of Europe in recent years. The number of judgments by the European Court of Human Rights that is not implemented, serious judgments, has increased as Russia and Azerbaijan and Turkey and others have shown you can get away with just not implementing judgments. And that just transforms the institution into something different. But the thing about the EU as opposed to the Council of Europe is that there is so much mutual trust required for this to work at all that it will be really dangerous. And I think that's what I suspect Jorbo doesn't mind if the EU breaks apart. I suspect when you listen to Orban, he sort of hedges his bets. He says, I'm in the EU as long as I get the money, but if the EU collapses, I'm fine too. That's why I spend so much money on it.
That's the concept of my question. It seems like Hungary and Poland and maybe some other countries, the Visegrad countries, want to keep having the money coming, but not uphold that part of the contract. So to me, it seems like logical that if someone breaches the contract or treaty they signed, they lose the privileges. So if they want to keep having the money coming, it's not like to me it's not a legal abstract about what you do. They breach the contract they broke it to get into the EU. So if they don't uphold the criteria, they shouldn't get any money because they broke their membership contract.
And there are two institutions whose job it is to be the guardians of this Commission and the European Court of Justice.
Yeah, but isn't it more dangerous to let people just getting all the money but not upholding the contract? It seems like that would destroy the EU in a way more definite way than some kind of a legal strategy to stop it from continuing?
Yeah, I mean, we can continue over pastry, I agree with you. The difficulty is that for these governments, they have a different vision of Europe. They have an authoritarian vision of their own, of how a society should be run. And they think they can get away with this. They think, because the experience of the last few years was that Hungary and Poland per capita, in adjusting for changing values, got more money from the EU than the allies of America got through the Marshall Plan after World War II every year. You know, this has been an enormous transfer of money. At the same time, which they deconstructed their systems. You know, Poland's deconstruction of the rule of law happened while the EU was giving more money every year as transfers than to any place in recent European history. So it worked for them. They could do both things. And that's what needs to change. And it will only change if there's an awareness of why this is so bad in other countries and in the institutions. And for a lot of governments, I mean, in Berlin, the last government, the sense was, it's not that serious. You know, it's perhaps one problem, but it's not the most serious problem. We have other issues with Poland. It was seen as just, what you say, a serious breach of contract, was not seen like this. It was seen like, it's annoying. It wasn't seen as it's existential.
But maybe one important point should be added here, right? We are in a trap. We are trapped by the veto power of these countries, right? So if we respond to the breach of contract in ways that they don't like, they can sabotage other important political processes in the EU by abusing their veto power.
Well, but if they are convicted in the European Court Justice for breach of contract, their veto won't apply because their membership would be suspended until they uphold the criteria again. So that's to me that's a kind of a situation that will resolve itself by convicting them for breach of contract.
To be honest, I fully agree with you. That would be perfect idea of
that's how it should be.
The mechanism of the European Union. That would be perfect if it worked like that, but it's not, unfortunately.
Yeah,
so
but I'm also just trying to understand that. I know that political criteria is different, but I'm just trying to understand the legal criteria, which is, well, goes beyond governments and is more, should at least ideally be more continuous.
Well, the question you're asking is the right question. I think if more people ask these questions, then we become more aware of the problem in Poland and that this is actually existential. So asking these questions is definitely the right way forward. Yeah, I suggest that you can still informally speak, that we would close the session. Thank you for all the great questions and great contributions. And yeah, I mean, keep in touch. And I think Denmark can play a role, and the idea of Reichstager is a great way forward. And we should. Oh yeah, and yeah, maybe also to announce that we have a debate after in the afternoon at 3 o'clock, which I can also recommend. Another important issue also for Denmark, the migration issue, and how maybe we can come up with a more humane migration policy in Europe, and the role Denmark could play. And we have your Danish Minister of Immigration and a German Minister who is going to talk about the plans of the German government and the coalition agreement, how they want to control borders, but also in line with human rights. So feel free to join us also in the afternoon. It's at 3 o'clock. And Zoe, my colleague, even offers to give you a tour of the parliament after, if you're interested in seeing maybe how this will be worked.
It's just a very quick practical announcement. If you'd like to join us for the second session, then please keep your name tags, or at least keep them somewhere. You don't have to wear them until 3 o'clock, so that you can get back into the parliament and use the same entrance as you did this morning, and same procedure. Yeah, of course, great if you come, 5 minutes before we start, but we hope to see many of you in your afternoon session as well. But let's give our panelists a big applause. Thank you so much.